In 1966, Representative Adam Clayton Powell Jr. was investigated by a House Special Committee, which found that Powell had appropriated congressional funds for his own personal use. He used funds meant for the House Education and Labor Committee to pay for a housekeeper at a property he owned in the Bahamas, and purchased airline tickets for himself, family, and friends using those same committee funds. Despite the committee investigation, the Senate took no formal action. Later that very year, Mr. Powell won re-election somehow, but Congress refused to seat him. Powell sued, arguing that he had a constitutional right to be seated as a representative to the district that elected him. His suit made it all the way to the Supreme Court. The court sided in favor of Powell, stating that, in judging the qualifications of its members, Congress is limited to the standing qualifications prescribed in the Constitution. These standing qualifications are laid out in Article 1, Section 2, and read, "No person shall be a representative who shall not have attained to the age of 25 years and been 7 years a citizen of the United States, and who shall not, when elected, be an inhabitant of that state in which he shall be chosen." In other words, the only requirement to be a congressperson is that you have to be at least 25 years old, you have to have been a citizen of the United States for 7 years, and you have to be an inhabitant of the state which you hope to represent in Congress. There's no requirement to be a good person, and nowhere in the Constitution does it say that you can't be a congressperson just because you embezzled and were corrupt during your last term. Congress, therefore, could not refuse to seat Powell because he was, quote, duly elected by the voters and was not ineligible to serve under any provision of the Constitution. If you're a member of the House of Representatives and you're trying to keep thieving Adam Clayton Powell Jr. out of the House of Representatives, this Supreme Court case is a bummer. But what's interesting is that the Congress does have a constitutional right to expel, and there's almost no limitations on that right. So the question you should be asking now is, couldn't the Congress just seat him and then immediately expel Mr. Powell? This is the part of the case that's not so clear-cut. Congress's power to expel is considered by most scholars to be exceptionally broad with few if any limits. In Powell v. McCormack, the Supreme Court made no formal ruling on the matter of expulsion. In other words, the Supreme Court said that Powell had to be seated, but made no comment whatsoever on whether or not the Congress could immediately expel him. However, the language of the decision seems to suggest that it may not be legal to expel a representative for conduct that occurred prior to their swearing in. This is probably why, after Powell was seated, there were no further serious attempts to remove him from office. In the written decision, the court cited a House Select Committee report that stated congressional precedent did not allow expulsion, quote, for reprehensible action prior to his election as member, unquote. Additionally, Justice William Douglas's concurring opinion stated that when voters elect a representative, quote, who is repulsive to the establishment in Congress, by what constitutional authority can that group of electors be disenfranchised, end quote. Additionally, the Powell decision cited excerpts from an 1876 Congressional Judiciary Committee, which convened to discuss the expulsion of 2 congressmen. The cited excerpts read, "Your committee are of the opinion that the House of Representatives has no authority to take jurisdiction of the violations of law or offenses committed against a previous Congress. The Constitution authorizes each House to, with the concurrence of 2/3, expel a member. It cannot vest in Congress jurisdiction to try a member for an offense committed before his election. The expulsion power exists to enable each House to exercise its constitutional function of legislation unobstructed. If the conduct of a member does not obstruct the legislative ability of Congress, then there likely isn't grounds for expulsion." The fact that the court cited this language from the Judiciary Committee's report suggests that the court views the expulsion power as at least somewhat limited. The principal legal argument against expelling a representative for misconduct that occurred prior to their swearing in comes from the language of the Constitution and the Bill of Rights itself. Article 1 of the Constitution states that the House, quote, shall be composed of members chosen by the people. And the 17th Amendment to the Constitution states that the Senate, quote, shall be composed of 2 senators from each state, elected by the people thereof. It follows, then, that to remove a House member because of behavior the voters were aware of would violate the rights of the member's own constituency to elect their congressperson, and thus would violate the Constitution's requirement that the people select their own representatives. Though no court has ever found that there are limitations placed on Congress's right to expel its members, this friction between the so far unlimited right of Congress to expel members and the people's right to elect representatives is why it's still unknown under what conditions the Congress can and cannot expel its members. It should be noted, however, that the fact that no court has ever ruled that there are limitations to Congress's expulsion power is likely a function of how rare congressional expulsions already are, as opposed to a judgment on their legality or illegality. After all, only 20 congresspeople have ever been expelled in all of American history. The legal questions surrounding this issue are complicated and are still subject to debate among constitutional scholars. Given that I am not a constitutional scholar, take my opinion with a grain of salt. The arguments I presented here are not my own, but are instead simplified and condensed versions of arguments made by experts in the field. They come primarily from papers published by the North Dakota Law Review, a document published by the Congressional Research Service, and another paper from the Fordham Law Review. I'll link all 30 of these documents in the description, so feel free to read them if you found this interesting, or if you just want to make sure I'm not lying to you. If you enjoyed what I had to say here, feel free to leave a like. If you hated what I had to say here, leave a comment and tell me why. This is Seabass Politics, and I'll see y'all later.